founder of Seller Legal, has focused his practice exclusively on labor and employment law. During his career, Richard has covered either by settlement or verdict over $100 million in damages for workers around the United States in cases involving overtime minimum wages, unpaid commissions, breach of contract, race discrimination, sex and pregnancy discrimination, and sexual harassment, and all other employment discrimination types of cases involving employees against employers. If you feel like your employer has violated your rights, contact Richard Seller Legal at 954-903-7475 for a free evaluation of your claims, or visit www.floridaovertimelawyer.com to fill out an evaluation form and receive a free copy of Richard's book, The Employee's Survival Guide to Wrongful Termination in Florida, or watch Richard Seller's legal YouTube channel for video guides on how to navigate a claim for wrongful termination. As always, their review of your situation and initial consultation is free of charge, and if they take your case, they do so on a contingency basis, which means they don't charge you any out-of-pocket money, whether they win or lose.
You are listening to the Ask the Experts show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 5 to 6 p.m. Now, get ready for more Ask the Experts.
And we are back. You can also listen to us on 1470 AM, 103.9 FM, 96.9 FM, and 95.3 FM. Four stations to choose from. We have gotten, over the last 3 weeks, so many emails from our listeners asking us to add an employment show, especially with everything that's going on. And we found one of the finest employment lawyers. You are going to learn so much today during the show. Let me introduce you to our new expert, Richard Seller with Richard Seller Law Firm. Hey, Richard.
Hey, Steve, how are you? Thanks for having me.
Good. You can hear us okay?
I can.
Okay, great. Well, first of all, tell everybody about your firm and yourself.
Sure. My name is Richard Seller. I've been practicing law for 20 years solely in the employment context. I run a law firm, Richard Seller Legal. It is one of the biggest employment law countries on the employee side in the country. We have 8 lawyers, a large number of staff, and we focus exclusively on representing employees. We don't represent employers.
What kind of phone calls are you getting now with the virus going on?
It's been crazy. There's so many problems in the economy with law firms and employment law firms. We're busier than ever. I mean, folks are getting laid off because they don't want to go into work because their employers aren't providing them with protective equipment. You're seeing a lot of illegal things happening in the workplace. Folks are getting fired because they need to take care of their kids and their employers are not understanding. So it's really running the whole gamut from discrimination to employers are stealing wages from employees and working them to the bone and then claiming they don't have any money. So it's been a busy time for us for sure.
You know what I'm worried about, Richard, and this is not really about employment law, but I'm worried about these people who are extending themselves out because they have not gotten a paycheck, and it's not their fault. And eventually this money is going to be owed, whether it's for car payments or city. You're not getting off for free with this.
Well, I think it's a short-sighted mentality that we're seeing from employers right now. They're in essence, survival mode. So they think, well, let me just steal now, and they should just be grateful to have a job. But the laws haven't been suspended in this country just because we're in a pandemic. So employee rights remain intact, and our phone is still ringing consistently. We're still in litigation. We're still negotiating and fighting. we're still negotiating and fighting on behalf of our clients and new clients nonstop.
Tell everybody what employment law does, what your firm does when it comes to employment law, because there's a lot of different areas.
There's so many different areas. So let me start with the basic principle that there are laws in this country, both on the federal level and the state level, that are designed to protect employee rights. Okay. So our firm, for example, on any given day can represent a whistleblower who objected fraud at the company and was fired. The same day we can represent an employee who hasn't been paid their overtime, or a woman who's been discriminated against based on her pregnancy or race. So employment law at its core is the concept of employees or individuals being represented who are illegally treated based on some sort of protected characteristic: race, religion, age, gender, sexual orientation, anything you can think of that is what we call an immutable characteristic, something that the employee can't change, is generally protected.
Are all terminations legal? Did you hear the question? He might have frozen up. Richard, can you still hear us? Well, we're waiting on Richard to come back. Looks like maybe his screen might have frozen up. Um, let's see, why don't we go to an early break, Ken, and let me see what's going on.
For the past 20 years, attorney Richard Seller, the managing partner and founder of Seller Legal, has focused his practice exclusively on labor and employment law. During his career, Richard has covered either by settlement or verdict over $100 million in damages for workers around the United States in cases involving overtime minimum wages, unpaid commissions, breach of contract, race discrimination, sex and pregnancy discrimination, and sexual harassment, and all other employment discrimination types of cases involving employees against employers. If you feel like your employer has violated your rights, contact Richard Seller Legal at 954-903-7475 for a free evaluation of your claims, or visit www.floridaovertimelawyer.com to fill out an evaluation form and receive a free copy of Richard's book, The Employee's Survival Guide to Wrongful Termination in Florida, or watch Richard Seller's legal YouTube channel for video guides on how to navigate a claim for wrongful termination. As always, their review of your situation and initial consultation is free of charge, and if they take your case, they do so on a contingency basis, which means they don't charge you any out-of-pocket money, whether they win or lose.
And we are back. It seems though Richard Sellers, his computer is freezing up. This is the first time we've had this problem. I'm hoping he will call into the show at 888-565-1470. Richard, if you hear this, please give us a call at 888-565-1470. We're talking about employment law today, and Richard has got one of the top he has probably the top employment law firm in all of South Florida. And because a lot of things they do are federal, they handle cases probably all over Florida as well as other areas of the country. So I think he's calling in now. He froze up. Let's see if we can get him back on the air.
Can you hear us, Richard?
Can you hear us, Richard?
Richard?
Yeah, I can hear you.
Richard?
Okay, it looks like you might have
Okay, it
frozen
looks
up.
Okay.
So we're back. I was just telling everybody my last question I asked you was, are all terminations
Are all
illegal?
termination?
No, so in Florida, there's a concept called at-will employment, which means that employees can be fired for a good reason, a bad reason, even a fake reason, so long as it's not an illegal reason. So as we discussed in my earlier answer, an illegal reason deals with, for example, race, religion, sex, pregnancy, disability. So an employer can go out and fire somebody unfairly, but that doesn't necessarily mean that that is illegal and that they would have a lawsuit or a cause of action.
Now, I wanted to ask you, because there's a lot of federal laws, you handle cases throughout Florida, actually, I'm sure outside of Florida.
We do. So, we're licensed in Florida, but a lot of our cases wind up taking us into other states and have over the years, for example, large class actions based on failures to pay properly. We've wound up in, almost every state: Texas, Mississippi, Alabama, Georgia, Tennessee. So our practice goes where it takes us.
So we had a employment attorney on our Houston show, and he would actually take a new business and create a employee handbook. Do you do that?
Well, that's not really what we do, because the employee handbook is based on the employer's needs, and we only represent employees. So I am a former defense lawyer. In the earlier portion of my career, I did represent employers, meaning the companies. But these days, we don't do employee handbooks because our rights are to attack the handbook if it's illegal or improper on behalf of employees.
We just got a text in from a listener wanting to know if they are an independent contractor, should they sign anything?
It's a good question. Obviously, it's a broad question. So let me answer it in a sort of general, sweeping tone, just because we're limited on time. There are certain factors that go into determining whether somebody's truly an independent contractor or an employee. Regardless of what the label is, even though the employer may call somebody an independent contractor, if the realities of the situation are that the individual is an employee, they're protected by all of these employee rights that a regular employee would be. So I don't know what the caller is asking that should be signed, but regardless of what the document says, titles and formalities are irrelevant. The courts look at the actual relationship of the parties to determine whether somebody is a contractor or not.
We're getting a lot of texts in. We just got another one in. What are your feelings on non-competes? Should that be signed?
Sure. So unfortunately, in our day and age, employers use non-compete agreements essentially as take it or leave it when somebody comes and works for a company. They're legal in the state of Florida. There are restrictions. They can't be overly broad in terms of geographic scope or time, but they are enforceable. And here's what I always tell potential clients is, you're not forced to sign a non-compete, but your employer or potential employer is not forced to hire you if you refuse to do that. So, be careful. Don't cut off your nose to spite your face, as they say, by refusing to sign a non-compete, and now you don't have a job.
Do all employees have to comply with the laws here in Florida?
Yeah, well, it's a good question. So for the most part, the answer is yes with qualifications, okay? The law generally is that employers that have less than 15 employees are traditionally not subject to discrimination laws. Okay? So if you've got a small mom and pop with 3 employees and they do something really illegal, let's say they say, I'm firing you because I don't like women. Believe it or not, what they're doing is disgusting, but because they're so small, they would not be in violation of any law because they're not big enough.
Well, we just got another text in. I don't think we've gotten this many texts in such a short period of time. Person is at their job, want to know how many employees does a company have to have before they have to offer health insurance?
Okay, so the answer is there's no legal requirement that a company offers health insurance. Under the Obamacare regulations, there were some changes made to that, but there is no per se law beyond larger employers. But the rule is, in essence, if your employer does offer health insurance, they have to offer it to everybody. They can't just offer it to some. But there's no hard and fast rule in terms of a small employer number count.
What are some of the things that employees can do now to protect themselves in the workplace?
Yeah, so the advice I give to every single employee, and we put this, if you go to our website, and not so much commercial here, but it's www.floridaovertimelawyer.com. There's a great section we have on there, which is really informational for potential employees. And there's something like the top 10 things every employee needs to know. And one of the things that we put on there is document, document, document. And what that means is that if an employee is going through something at work, even if it's just a text message to their boss complaining about it or documenting it, of course in a professional way, there's some sort of paper trail or record that what's going on happened. And that's the best thing that an employee can do. If they're being treated illegally or unfairly in the workplace, my advice is always going to be send a professional email or a text message to your manager or the boss explaining your concerns. Don't be aggressive. Don't make demands. Just ask that the situation be remedied. Because if that happens and the employee is objecting to something illegal and gets retaliated against or fired, we have a paper trail to confirm that there was actually an objection made. And what we always say in this practice is, if it's not in writing, it never happened. Because guess what? The employer is going to lie that you ever objected to anything. So protect yourselves and document.
Another text, what do you do if you know your employer is doing something illegal? Do you go to them or do you fall under the whistleblower?
Yeah, so that dovetails into the last answer I just gave, okay? In Florida, there's a whistleblower statute that applies to employers who have 10 or more employees. And what that law says is that if an employee objects to something that they believe or reasonably believe to be illegal, and the employer retaliates against them and fires them or demotes them or cuts their pay, they would have a case as a protected whistleblower. Okay? So my advice is always, if you see something illegal, say something about it. Because it's not just about you observing something, but we've had cases, for example, where a medical company is injecting patients with non-conforming drugs, with altered drugs. And our client came forward and saved lives. And the client got fired, but we were able to represent and secure a very large settlement on behalf of this client for coming forward and doing the right thing.
What was the movie with Michael Douglas? He was working for a tech company, and he was good friends with all the people on his staff,
Yep.
and he took his hand and kind of hit one of the girl staff members in the tuchus.
Yep.
And she had to kind of report that. And it didn't seem like a big deal.
No, I'll tell you what, the old boys club is dead. So let me say this. I've got a wife and a daughter. So if somebody ever did that to my wife or daughter, I don't know how I would react. But
Right.
the Me Too movement has been, a big push where women finally felt comfortable enough to come forward and say, hey, this isn't right, So there's been a big push, as you guys know, it's been all over the news, Harvey Weinstein. And so women in the last 3 to 5 years have been at the forefront of employment law because they know that they have a voice and that they are now protected. Okay? Now, the counter argument and some of the things that have cropped up as well is that for every valid claim, there are a few invalid claims where women are using it as leverage now against their employers when, for example, they're not doing a good job. Some women have fabricated claims to say, I'm being sexually harassed. So, of course, it's a balancing. There's always going to be a bad apple in the bunch, but it is important for women to come forward and assert their rights.
Here's another text that just came in. Great show today. Will your guest tell us about overtime law?
Now, you just hit my sweet spot. I love talking about overtime. Okay. Here's the general rule. If an hourly paid employee works more than 40 hours per week, with very few exceptions, they need to be paid time and a half their hourly rate. Quick math. Nobody likes math, but if you make $10 an hour, for the first 40 hours, you get $10. If you work 5 hours after that, you get paid $15 for every overtime hour you work. Now, there are exceptions. If you're a salaried employee and you get a guaranteed salary and you're an executive, you can hire, you can fire, you can discipline, or you're making major decisions on behalf of the company, scheduling employees, doing evaluations, you may not be entitled to overtime. So there's so many different nuances. What we always encourage people to do is reach out to us, contact us, let us evaluate your situation. But with our time constraints today, at least that's the general rule for overtime.
So they can call you now with the virus going on, and I guess you'd use Zoom or something, but tell us about how you're compensated.
Sure. So what we do is unlike a lot of other employment law firms. A lot of employment law firms, when somebody's been wrongfully fired, they charge them $500 or $400 to come in for a 1-hour evaluation, only to be told they don't have a case. So now not only have they lost their job, but they've lost hundreds of dollars paying a lawyer to tell them something they could have found on the internet or on our website. So our firm is based upon a model, and it's a unique one, where we are contingency-based only, which means we only get paid if we take your case and get you paid, okay? So if we take your case and fight it for 2 years and we can't get you paid, God forbid, you don't owe us anything. So, and the reason or the motive behind this is because we align our interests with our clients, okay? If the client's paying an employment lawyer by the hour, what's the motive of the employment lawyer? The employment lawyer is going to rack up a bill because they're getting paid whether they win or lose. But what we tell our clients is that we're in this with you. So if you do well, we do well. If we don't recover for you, we cry in our Cheerios the way you do, and you walk away and you don't owe us anything.
I am shocked because I had talked to employment attorneys before, and you're right, they do charge $400 or $500 just to sit down to find out if they have a case. I think that is wonderful how you run your firm.
Yeah, some people think we're nuts, but you know what? We've been doing it for a long time. And at the end of the day, yes, we are running a law firm and a business, but we're here to help people. So, it's a feel-good thing, but it's also we feel the right thing to do.
Hey, Richard, does anything else that makes you different from the other employment law firms out there?
Yeah, I think it's just our style and our approach. Going back to our information section on the website, we give a list of, I think it's 10 or 12 things that you need to ask your employment lawyer before you hire them, okay? And one of them is, have you ever gone to trial? The amazing thing is the internet makes everybody look really professional on their websites, but there's so many unqualified folks out there who have never set foot in a courtroom and are just willing to take the very best or lowest offer they can get just to get a quick buck and get out. That doesn't serve our clients' interests. So our lawyers are trial lawyers. We go to trial every year. And when we get asked the question, we can tell our clients, we've gone to trial on this, we've gone to trial on that, we've handled these types of class actions. And truthfully, although somebody will find some fact pattern, I can't think of a single type of situation that we haven't handled based on our collective experience at the firm. So there's nothing that really shocks us at this point.
So litigation doesn't bother you at all?
No. In fact, that's one of the other questions you need to ask is, how often do you litigate? So we have 5 lawyers specifically identified in our firm as our litigation team. All they do is litigation. And then we have another section of lawyers in our firm who are tasked with handling the pre-litigation phase of the case. So, we make sure that we're handling it from the beginning to the end with the right qualified lawyers, and myself and my partner getting involved throughout the entire process.
I'm going to ask you towards the end of the show now, tell me why I should retain your firm to represent me.
Sure. It's a great question. Let me say this. Any lawyer that guarantees a client a result is lying. And if a lawyer ever says to you, this is a slam dunk, my advice to all your listeners, alert, alert, run away. Okay? So, we always start the relationship with reasonable expectations. We've had clients that have come in with great cases saying they don't want to take less than $20 million when their case, even though it's a good case, might only be worth $25,000. And we've said to those clients, we're not the firm for you. And the reason why we say that is when you go into a relationship and you're not on the same page in terms of expectations, you're heading for a divorce. Okay? So part of what we sell ourselves on is we're going to be honest, maybe brutally honest sometimes, but we're going to set expectations with the clients from the beginning. And it goes back to our business model that we're in this together. So we have every incentive in the world to get you as much money as we can get you, but we're not going to lie to you and we're not going to fluff you. So as long as you want to listen to our advice, you're the client, you always make the decisions. You could take our advice and throw it in the garbage, but you're always going to get candid, straightforward advice, truthfully, whether you like it or not.
God, I just fell in love with your firm. Richard, give everybody your phone number and your website address.
Yeah. First of all, if you need to contact us, if you have a question, send an email to intake@floridaovertimelawyer.com. Check out our website at www.floridaovertimelawyer.com. And our toll-free number is 866-344-WAGE, which is 9243. And one last piece, what I would encourage the folks listening to do, we put up content videos on our YouTube channel. So a lot of the questions you've asked, I've answered them on video and they're on YouTube. I'd encourage you guys to go take a look and ask questions if you have them.
Well, I wish you could see all the people who text us today. You'll be back with us again next month with more Ask the Experts, and we'll see you guys on Monday, 6 to 7. Thanks, Richard.
Thank you.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not